Hi guys, it's Kathy. I hope you're doing well. We made it to Monday. The best thing about today is last week is freaking over. No more last week. Whew. All right. They're coming. They're coming. They're coming. Don't worry. It's early. They never are here at the beginning. But they're coming. Don't worry. It's all good. So, we are going to do this today. Doesn't that look great? I don't know if you can see it, but right there, the top right, not top because nothing's at the top, it's all black. It says Mr. Brooks. So that's what we're going to do today. And I can't wait. I haven't seen it. I did do something different this time. I read some of the comments on this video. So it should be good. The comments make it feel like it's going to be really good. So let's press play. I know how to do that.
Okay, we make some time for the attorneys to appear and to speak with their clients. And we're back on record to continue the fifth review and permanency planning hearing in this matter. May I have the names of our participants, please?
Good afternoon, Your Honor. Nicole Underwood, lawyer regarding ad litem. Ms. Thomas will be joining momentarily.
Macy Moore, foster care worker with Catholic Charities.
Michael McFarland, representing Mother. You have a brief opening statement when it's opportune. Mother, please introduce yourself.
Christina Lemley, mother of Kenzie Wright.
Thank you. I can hear you well.
Michael Brooks, I represent the father, Matthew Wright. Mr. Wright, are you present?
Look. Oh my gosh, we can see Mr. Brooks more clearly now. He's right here. He's left, top left. We can see Mr. Brooks more clearly now. No, I'm not covering up Mother. She's not on the screen that I can see. There's nothing under my square. I'll show you. See? Oops. See? So, I don't know where Mother is, but we get to see Mr. Brooks infuriate us right to our faces for once. I love it.
Mr. Wright, are you there?
Can you hear me?
Yes.
There he is.
All right. Yeah. Matthew Wright, father.
All right, Mr. McFarland, would you like to wait for the department to be present?
Probably it'll just tell them where we're going to go. And
Yeah, I didn't realize that we didn't have Ms. Thomas. Good catch, Ms. Underwood.
you text her.
Yeah, she's, yeah.
I'm sure she'll be very short. As I recall from last week, it was mainly to allow the parents the opportunity to testify.
That's my recollection.
Updates?
I do not have any updates.
There is also the opportunity for me to call a professional witness, a counselor, on the rebuttal. You also get a chance to do that for the next hearing, as I was on vacation Friday and Monday. So we will be possibly calling her at the next hearing, not today, just to let everybody know.
I just need to go into a full recess because the second I do, she'll log in.
Well, no one's actually speaking right now.
She should be logging
CJ.
on. She just gotta be within a minute
We're
or
just
so.
waiting,
There she is.
but you should be able to hear the noise. I'm gonna move Twitch chat.
Are we waiting for Nastasia?
We are, but she should be joining us right now.
Twitch chat down here.
We are ready for your appearance, Ms. Thomas.
Wait, I don't want to cover Mr. Brooks.
Thank you, Honor, and I apologize to the court. I'm in the middle
Hi.
of a brief and just got lost in time, so I apologize for that. Anastasia Thomas, counsel for the department.
Very well. We're on record for a continuation of last week's review and permanency planning hearing. The rest of our participants have done their introductions. Mr. McFarland had a chance to talk to his client. Mr. Brooks was also a bit delayed in joining us. It was a last minute carryover from last week, so you weren't the only one that was a little bit surprised by this afternoon's events, but we're back on record. We have everybody. Your caseworker, Ms. Moore, informed us that she doesn't have any updates. Mr. McFarland let us know that the professional counselor he was considering calling will not be part of today's hearing. Did you have anything else preliminary?
Well, you've given us the option of calling her at the next hearing. We may exercise that.
Thank you for the warning. Anything else?
My client will be testifying.
Okay. Mr. Brooks, any opening comments from you?
No.
Okay.
Wow.
Any updates or comments?
Mr. Brooks,
I have no updates, Your Honor, but Miss,
sir, we came here to hear you infuriate us. Monica just gave me some cheers on Twitch. Did it work? Did I miss it? Did it flash on the screen? Because it should work. I missed it. I was watching. I thought I was watching. But
as a comment, Miss
thank you,
Wright,
Monica. Thank you.
sorry, Miss Moore
Yay.
did notify or ask Miss Reyes, who is the counselor, to be present today, so I will intend on calling her as a witness today.
I do have someone logged in under Elizabeth Reyes.
That sounds
Okay,
delicious.
Ms. Thomas, do you
CJ.
have any comments before we get started?
I didn't see it.
No, Your Honor, I believe that Ms. Moore had circulated the report that was admitted into rebuttal evidence at the last week's hearing by Ms. Underwood. So other than that, I don't think anything else has been provided. And I did not intend on calling anyone else, as Ms. Underwood was going to call Ms. Reyes, and then the respective parent attorneys were going to call their clients.
Thank you. All right, Mr. McFarland, would you like to go first?
Yes. Please, if my client could be sworn in.
Okay. Have your names, if you could swear in, Ms. Christina Lemley, please.
Ms. Lemley, can you hear me?
Yes.
Thank you. Can you raise your right hand, please?
She's not using her video, I think, because her connection's not great.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, I can tell the court I had great difficulty with her video off. May have to do that.
Her video is currently off.
Oh, thank you. Christina, just the first instruction, as we discussed, I'd like you to speak loud and slow, since you and I recognize your reception's not real great, okay?
Yes.
Thank you. Loud and clear, we hear you. You had 3 points you wanted to testify about today. What was your first point of concern?
The first item of concern that I had was going back through the previous
Hang on.
and
Ms. Lemley, we can only hear about every other word. Can you maybe step out of your car where you don't have that surrounding you? Maybe we can then hear you better.
yes.
Miss
I'll be right
Lemley,
back. Hang on.
do you want your child? I don't know.
It
Is that better?
So continue loud and slow. Your first concern was what?
My first concern or question, I know it had come up 2 or 3 hearings ago about Kenzie's behavior after visitations, and it was stated that that was going to be looked into further to see if we could figure out where that was coming from or how to help ease that, fix that. My curiosity or question was, had anybody done any further research or evaluating into finding out any of that?
You had not heard any testimony regarding that last time, correct?
Correct.
Okay, and your second question was?
An additional question I had was that I went through an entire 90-day review period where I was under the impression that I could not, go anywhere with my daughter, travel with my daughter. I had, multiple times asked if I could take her to the park. I was told no. If I wanted to take her outside of the office building, I had to surrender my car keys to a worker.
Listen, guys, I know we're listening to Mom first, but these trials, these hearings never start until the bottom right corner, Miss Thomas opens her mouth. So take what Mom says as a grain of salt and listen. Miss Thomas will tell us what's really going on.
And then could receive them back once I returned into the building with her, which I had no problems with, didn't fuss about. And then at my family team meeting, like 4 days before court, the supervisor informed me that if I would have had a car seat with me, I could have been leaving with her the whole time.
So your concern is that that was not brought to your attention from the beginning. Is that what I'm hearing?
Correct.
That you had lost an opportunity because you weren't advised. Is that basically your point?
Yes, because I know at one point, leading up to this, the big concern has been that I'm not as far in the gaining of parenting time that I should be this far into the case. And I feel like a part of that's not my fault when I went a whole 90 days of one person telling me one thing and another person, stating later on that was the wrong information for a whole 90 days.
Who was the supervisor at the family team meeting that instructed that you could have had parenting time if you had a vehicle?
Kristen?
You know what Kristen's last name is?
I do, and it is on the tip of my tongue, but I cannot spit it out at the moment. Long, really curly hair.
Okay, you had a third concern and last concern. What was that last concern?
Somebody said in comments from Debbie's talking about in chat that another channel reminds her of me, and it is another channel. I started a different channel with just videos, not me, no talking, nothing. But it's really hard because right now I just paused this video. All of my archives, I talk the whole way through them and I laugh the whole way through them. So when I try to get some of my old content to put on my new channel, I try to get me out of it completely, which is impossible. So every once in a while you'll hear me laugh or say something in this other channel where I'm not supposed to be seen or heard, I guess. And somebody said to me in comments the other day, some guy said, I left like 2 giggles in a video because I had accidentally giggled over a very good part, because you know what, it was funny. So it was just 2 tiny little ones in the video, and of course I got a comment, oh, I wish you would stop giggling, it's really annoying. And then somebody replied, oh, this creator's just ripping content from some other content creator's page. So my fingers were ready. I'm like, oh, I did it. I'm ripping my own content, and it's my giggle, and I'm sorry if you don't like it. Oh man, yeah, that's my other channel. Thanks for subscribing, Debbie. Debbie, you've been with me for it feels like since day one. I know it wasn't day one, but you've been with me for a long, long, long time. And I do appreciate you a lot.
My not necessarily last concern, or more so my last comment, was in when it was just my behavior and my actions upon the visitation, in which was ended early, was just, nonchalant, didn't care. I don't feel like that was a very accurate assessment of my behavior. Because the falling to pieces completely on the inside and freaking out, that's not any way to handle a situation. So I felt like there was no other way to handle that situation outside of stay calm. Clearly, I had, what was I going to do? Take her and run through the property to try and take off? I mean, there was no other option than to, bring her out front, give her to Miss Moore, and accept the fact that the situation was what it was, and there was no reason to cause problem. So I don't feel that assessment or opinion of how I acted was very accurate at all.
You believe not having an outburst was best for your child? Not having an outburst, is that what we're hearing?
Exactly, because I will say about the second that she was out of sight, I mean, I literally hit my knees in the dirt in hyperventilating tears, but she didn't need to see that. She didn't need to be drawn into that. It was already a messy enough situation as it was.
Thank you. And you're asking lastly today for the court to still pursue the guardianship which you are agreeable with, correct?
Absolutely.
Thank you. I have no further questions, but we'll see if anybody else.
Oh, that checks out though, guys. That checks out. I remember when, the handful of times that my husband actually came and got the kids after he left. Like I was like very cheerful. Go, you're going to see your dad. You're going to have so much fun. Wait till you meet his new girlfriend. I was very happy for them. I made it sound like it was a field trip. You know what I mean? But the second everybody left, yeah. So that, her little story there does check out.
Has questions for you, okay?
Yep.
Okay, questions, Ms. Thomas?
Thank you, Your Honor. Ms. Lumley, as it relates to the post-visitation behavior for your child, what steps did you take to inquire as whether anything was being pursued for trying to secure more information on that issue?
I guess I don't totally understand the question.
What did you do to determine what was happening with your daughter after visits, why her behavior is different?
I had been, sitting and doing Google research on, what could be causing an infant or, young toddler to get upset after parent visitations, trying to read into it a little bit. There's not a lot of it really that I understand, not being a psychologist or a therapist myself. However, I feel like,
Ms. Lumley, did you ever reach out to the caseworker and follow up on whether a referral for any service had been made?
No, I didn't know that that was a.
And did you ever, it's a yes or no question. And did you ever reach out to your attorney to determine whether there was any legal recourse that could happen so that question could be answered?
Your Honor, I'm objecting attorney-client privilege.
Attorney-client
Would not
privilege.
allow my client
That's
without
right.
us
That's
discussing this to discuss what our conversations entail. She can ask if she reached out to her attorney as far as the discussions, that's confidential and privileged. That'd be my objection.
Response?
I can move on. That's fine. And as it relates to you bringing up something, well, let me just clarify. During the last review period, so from July 8th until the incident on September 11th, were you able to take your child for unsupervised visits anywhere you wanted to go?
Yes, the period I'm speaking of is the
Yes
one
or
from
no?
April.
It's a yes or no question.
Yes.
Okay. And you were bringing up a prior review period, which I think this is what you were trying to finish, but let me just ask the questions, okay? you were bringing up a prior review period that we already had a hearing on, correct?
Correct?
Okay. And since then, that issue was remedied and you were permitted to take your child wherever you wanted, correct?
Yes.
Okay. Thank you. I have no further questions.
Any questions, Mr. Brooks?
No, Your Honor.
Ms. Underwood?
I have no further questions.
Okay, any other witnesses, Mr. McFarland?
No, thank you.
Okay, we have Ms. Reyes here, who's a professional witness. Mr. Brooks, did you want to go first, or did you want to allow Ms. Reyes to testify for Ms. Underwood first? Do you mind?
No, I think that would probably be best. Let's have Ms. Reyes go first and then my client, so he can hear what she has to say.
That's right, Mr. Brooks. You earn your paycheck today. Look how hard you're working. Alan, I tried to reply to you in chat, but YouTube won't let me. It's parental restoration. They got their kid or kids taken away. It sounds like it's just one child and a very, very tiny baby. So they're in trouble and they're trying to restore their rights as a parent.
Any objections, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
None.
Okay, Ms. Underwood, may I ask you to call Ms. Reyes?
Yes, I'll call Elizabeth Reyes.
Okay.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Reyes, could you please state your full name for the record?
Oh my God, ladies.
Elizabeth
Yes.
Reyes.
And Ms. Reyes, what is your occupation?
I am a clinical social worker.
And where is it that you currently work?
Saginaw Odyssey House.
Okay. And are you familiar with Christina Lemley?
Yes, I am.
Okay. And how do you know Miss Lemley?
Well, I was aware of Miss Lemley when she was in our residential program in Flint. She attended groups that I facilitated, and we had some discussions regarding her child as well. But then when she came up to Saginaw to our outpatient program, our outpatient clinician left our program in May, and I took over that caseload. And so Christina was on my caseload, even though there was a period of time where she had been accidentally discharged from our program. And it took about a month or so to get her back into the program.
Okay. So for a period of how many months would you say that you worked with Miss Lemley?
Oh. How long I worked with her, or how long we were supposed to be working together?
Well, let's start with how long you actually worked with her.
I started seeing outpatient clients in the third week in June. I met with Christina briefly, I think a couple of times, but nothing that we really put down on paper. I can't remember the date that she left our program. But she had missed quite a few appointments in between.
Okay. Did you provide a discharge summary and transition plan to the caseworker, Miss Moore?
Yes, I did.
Okay. In that report, you indicated that the reason for discharge was dropped out of treatment. So did Miss Lemley successfully complete treatment at Odyssey House?
Not with our outpatient program, because She had missed too many appointments to say that.
Okay. Now, as far as, there's a couple of, it looks like drug screens that were positive for methamphetamine, one in May and one in July. Can you confirm that those were positive screens?
I can't really comment on the one in May because it happened when she had been discharged from our program. The one in July, I can comment that yes, it was positive.
Okay. And did Miss Lumley admit to using to you after the positive screen?
Yes, she did.
Okay. So it wouldn't be accurate then if Miss Lumley claimed that she tested positive because she was cleaning a former resident's room and there may have been residue. That would be inaccurate.
Yes, it would.
Based on your interactions with Miss Lumley as well as the drug screens, what would you believe her Miss Lumley's risk of relapse would be at this time?
At this time, I would say her relapse risk is very high.
Thank you. I have no further questions.
Higher
But the other
than Miss
attorneys may.
Lemley?
Questions, Ms. Thomas?
Ms. Reyes, in your discharge summary, there was some information regarding maybe the current plan for Ms. Lumley. Had she discussed with you her intentions of moving back towards the Jackson area?
She did say that she was moving back into that area. Honestly, I can't tell you when it was. It was over the phone. We talked about it, and she did not provide me with a forwarding address.
Okay. And did you have any, or I mean, as a treating clinician for her, do you have any concerns about her being away from like the sober living community that she established in the Saginaw area?
Yes.
And can you summarize, I guess, based on the termination report, where she was in her treatment at the time you drafted the termination report?
Physically where she was?
I guess I'm thinking more of from a substance abuse treatment lens, maybe her stage of, like, was she in contemplation? Was she in pre-contemplation, active recovery, anything like that?
I would say she was probably back in contemplation. She went back and forth a bit, and yeah.
Okay. I have no further questions. Thank you.
Mr. Brooks, any questions?
I do not.
Sir McFarland?
What do you mean by she went back and forth? Can you tell us what that means?
It means that while she was in residential treatment, she was doing very well. Once she got into the outpatient and recovery housing, I think she was put at risk due to not having strong enough coping skills. I'm not saying that is necessarily a fault of her own. She felt she was doing what she needed to do for her child.
You don't have any proof of after she left your program of using any controlled substances, do you?
No.
Wouldn't it be true that many people who leave an inpatient program are at high risk? That's the nature of being in an inpatient program and being discharged, correct?
Many people do, yes.
Thank you. You indicated that she missed quite a few classes. Can you tell me how many classes there were and how many she missed?
I can pull out my planner and count the appointments she missed with me.
Or how many scheduled, do you know how many scheduled appointments she had with you? Just off the top of your head, I'm asking.
Off the top of my head, I don't know. I do have them written in my planner, and we would reschedule the appointment, and then there was either a no-show or I have to work or something that came up.
And you said her starting late was not her fault. There's some scheduling snafu, if I heard you correctly, did I?
I'm sorry, starting late?
Yeah, she did. Yeah, you said there was some snafu at the beginning of some, that was not her fault, you had mentioned.
It's her
When she
fault.
left residential,
No,
I said
think when
that
Go ahead.
I was saying that it wasn't her fault, really, that she left the residential. She felt like she was doing what she needed to do for her child. But I don't think she was ready for that move yet.
I think my question is more getting into it. There was a snafu with her getting in. Is that what I heard? That was not her fault?
She was accidentally discharged from the outpatient program, and it took about a month to get her back on.
Thank you. Okay, thank you for that clarification. I have no further questions.
Okay, Ms. Reyes, did you say that she left inpatient before she was ready or dropped out of outpatient before she was ready?
I would say both.
Thank you for the clarification. Okay,
I'm sorry?
any redirect, Ms. Underwood?
No, Your Honor.
I do.
Go ahead.
Sorry, redirect or recross.
Questions based on my questions?
Yes. On your discharge paper, your summary, you did not state that she any issues with her inpatient program, right?
Correct. I was only addressing her outpatient treatment on this discharge summary.
Have you told anybody other than in court here today what you just indicated about her inpatient performance?
I think I told her that I didn't think she was really ready. I was willing to work with her, but I don't think she was ready for outpatient.
Okay, thank you. I have nothing further.
Okay, any other questions, Ms. Thomas?
No, Your Honor, thank you.
Mr. Brooks?
No,
Very well. Thank you for your testimony. Any reason we shouldn't thank and excuse the counselor?
fine, Your Honor.
Thank you. Okay, thank you, Ms. Reyes, for your time and your testimony.
Thank you.
Okay, your client has, Ms. Christina Lemley has her Zoom hand raised.
Oh, I intend to recall her, Your Honor.
Okay, all right. Well, I think your client, I have in my notes that your client testified extensively last time as well.
It's just regarding the testimony that this worker gave, Your Honor.
I understand, but today was mostly to allow Mr. Matthew Wright to testify. And I would like to give him the opportunity to do that today. My docket is, I'm scheduled for a trial to begin at 2:00.
Will we be continuing this hearing then at another date, Your Honor?
Well, we may need to,
Okay,
but
thank you.
part of, I mean, and there was a lot of reasons for the delay, but it was also in large part to allow you to have another 15-minute conversation with her before we started today. So,
I do appreciate her phone wasn't working when I tried.
yes. So, and those issues have been ongoing. We've asked her to try to make sure that she can participate by Zoom. So I'd like to go to Mr. Brooks to allow Mr. Wright to testify today. Mr. Brooks, are you ready?
Yes, I am.
Mr. Matthew Wright, are you
I
ready?
like them, Bobby.
Yes, but
Catwoman.
as of last week, we adjourned this for this week because it was only a 15-minute allotted time period, and I didn't feel like we were going to be able to get out what I needed to get out in 15 minutes. So when here we are with 10 minutes, that's less than last week.
Okay, do you want to testify today or do you want me to look for another day?
I would like for another day.
Okay, so I have some
Please.
time. I mean, I'd like to give you at least 10 minutes to testify, Mr. Wright, today. So why don't we, Deputy Ames, please swear in Mr. Wright, and I'm going to allow Mr. Brooks to body your him, and we'll see how far we can get.
Mr. Wright, can you raise your right hand, please, sir, and let me know it's raised?
Yes, it's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Brooks.
Mr. Wright, I have read the rather lengthy email you sent some caseworker. Is that what we're going to discuss today? The things you said to her, or is this?
No. What I would like to discuss is the fact of we're going off of all this, off of the evidence of abuse or neglect that was unsubstantiated. They're wanting me to take domestic violence classes for a domestic violence that was basically proven to be untrue and that I beat in a courtroom. So I don't understand really why.
Can we stop there a minute?
Yes. Yep.
You were charged with domestic violence?
That's what started all of this.
All
is
right.
I got arrested. Yes.
All right. You were what court were you charged with domestic violence?
Lenawee County Court.
Mr. Brooks, I'm sorry to interrupt, but I do want to remind you that these parties are well past the adjudication standpoint. The child has been removed since June 21st, 2024. And the case services plan has been in place for several review periods. I think today is technically our, let's see, 4th or 5th review perhaps. So fifth review. So if I could please make sure that you are staying within the confines of today's hearing, I would appreciate it, which is just the last report.
Thank you, Your Honor. All right, moving on, sir. What have you got on your mind to the limited time we have today?
Those are things, and the reason why I'm bringing them up now and not before is because obviously it took this long to figure out the court processes and everything, and I am just now basically kind of getting up to speed on how this all works. So I apologize for bringing that up now and not before, but now I understand what is going on, and I understand the fact of we are going through all this off of something that wasn't even a thing. Like it didn't even happen. So I don't understand why Kenzie didn't even come to me when Christy went to jail. Why was I not given guardianship of my daughter? Because no one substantiated the evidence. All they did was talk to Christy's parents, her father, that was in on the false allegations.
Well, so you were never convicted of a thing?
No.
Mr. Brooks, sir, ask
so
him
you're
questions.
asking the court now why you didn't get your child back at that point.
Yeah.
And you haven't gotten the child back since that point.
Nope.
Okay, I'm looking at Miss Thomas, bottom right corner. Her expressions throughout this when the parents speak, because they tell us everything we need to know.
And the reason I don't.
In the last 3 months, you have not had the child with you. Is that right?
Well, other than when Christy brought her over to my house.
All right. My next question, that following up on that observation from you, is this. The report that I'm reading says you have not participated in any of the case service plan that was designed for you. Are you aware of that?
Yes. And then there are reasons behind that.
What are the reasons?
One is, like I said, they want me to take a bunch of domestic violence stuff for a domestic violence that never happened. So that, I don't understand why that's even there. And honestly, the other stuff is I don't agree with it because this is all, none of this should even be in court right now because, there was no evidence of fucking any of
Okay, Mr. Wright, I'm not going to tolerate profanity this afternoon.
I'm sorry. Yes, I'm sorry. I'm a little worked up on this. But there's no proof of any violence or anything like that. The one allegation was proven to be false, and they're going off of a false statement, which originated all of this, Oh, for somebody
Okay,
that's already
I
biased towards
I
me.
just want to clarify something else for the record, for you, Mr. Brooks and Mr. Wright. So the adjudication order, reflects that back in July of 2024, that Mr. Wright entered a no contest plea to the allegations in the, petition, which would mean that the allegations in the petition, were taken and used to craft the case services plan. So I just wanted to make sure that the record was clear on that point, Mr. Brooks, as far as moving forward on relevant questioning.
As I
chime
recall, I was not present that day, but someone had to sit in for me, but I could be wrong. But in any event, to get back to you, sir,
Yes.
no, wait, I want to say something to you so you get it.
Yep.
I understand that you don't believe that there's been substantiated claims that justify your case service plan. Is that a fair statement?
Yes.
Now, once a court has made a ruling, there is no need for anybody to agree or disagree with what the court has ordered. It must be obeyed. Do you understand that?
Yes, but can I chime in on my part? When I made that basically no contest,
Yeah.
I hadn't gone to my court stuff for the domestic, so I couldn't say, "Hey, I didn't do this." But after that, I mean, so I basically, you guys kind of railroaded me into a corner where I had no choice but to stand no contest or say no contest.
Well, you had more than one option, sir. You could have pled responsible, not responsible, or no contest. Do you understand that?
I mean, yeah, I mean, that's what the no contest is, right? No, not guilty.
No, it's not at all. It's just the opposite. It means the court can treat the no contest plea as a guilty plea. Just the opposite of what you just said.
And he knew that, and they told him.
We go back to the beginning and restart this because obviously it
No,
needs to be
we're gonna
changed because
object.
I didn't do anything.
We've gone way farther beyond what we've needed to go for at this point. We're testifying to things that happened over a year ago. My notes indicate that Mr. Wright's rights were discussed and put on the record at
Were
that hearing,
violated.
and he still chose to.
They were
proceed.
violated.
And so,
Not your right to
again, I
remain
believe we are
silent.
far beyond the scope
wasn't
of
violated.
the last review.
Yes,
Your
Mr.
Honor,
Brooks, do you
may
have
I-
any questions? Sorry, go ahead,
May-
Ms. Thomas.
Your Honor, I'm sorry. I just want to clarify for the record. This is really bothering me. Mr. Wright actually had a bench trial in which he testified on his own behalf. On July 26, 2024, Mom had taken a no contest plea and Dad had asserted his right to a bench trial. At that time, he didn't know Kenzie's birth date. He asserted that Mom was beat up by some other guy, and that's how CPS got involved. He admitted to using Beth and would have used a couple of days prior from the trial. He was still living at a fifth wheel on a friend's property. He had a tree trimming service, but no license. There's just so much that we have in the record. And I just don't think it's appropriate for a review portion. And he's clearly not been paying attention and or intoxicated to the extent that he doesn't remember what's happening. And I think that we're wasting the court's resources at this point in time, unless he has something to say about what's happening in the last review period.
And for the record, I'm going to review that as well. This looks like this was a case that started with Judge Anzalone. And it may have actually been a bench trial in front of her. It doesn't look like I don't know. This is very strange. There's a lot of signatures from Judge Anzalone, but I'll review the record and make sure that the adjudication order is correct. But I do have, at least in the adjudication order as it relates to Mom, that father's bench trial was requested and was scheduled for July 26th. So that is pretty consistent with what you're laying on the record today.
And Your Honor, you did sign an adjudication order for Dad on July 26th. It looks like it was entered into the record or stamped on July 29th. And you did indicate that by preponderance of the evidence after a trial, the statutory grounds were met.
Okay. All right, anybody else have anything for the record as far as what got us here for Mr. Wright back in July of 2024?
Only thing I want to know is, are you going to schedule another hearing for him to continue talking about what's on his mind?
Mr. Brooks, if there's anything that he wants to testify to as far as the last court report, now would be the opportunity to do that. But I am not going to allow any.
I don't understand what's going on with Mr. Brooks. He is not a stupid man. And, you know, he fights hard for his clients, but right now he didn't ask him not one question about what happened during the last review period with him and his plan and his child. He let his client go off the rails, lying the whole time, because Miss Thomas told us that. She has it all there. And didn't ask him one question. And now he's asking for a longer period of time for him to just do it more? That's not like him. He's normally on top of things.
Further exploration into what happened in the summer of 2024. So if you'd like to lead him through any questions on that point, I'd like him to go through that, because I'm not going to reschedule this simply to allow him to talk about things that are inadmissible anyway for purposes of today's court review.
Did you understand what the court said, sir?
Yeah, basically don't bring up what has happened prior to the last review. So I do have something to bring up on that. Miss Moore is constantly making the allegation basically that I frighten her or whatever it is, where she won't meet with me or won't come to my residence and all this, and I'm out of control. But when she came and took my child, I mean, that would have been a prime moment to see exactly how I am at that point, to where I'm,
3 months
mad
ago,
or
sir.
upset. And I did nothing, just like I
Sir.
always do. I walked away because
Sir.
there's no point in making a big thing of it.
Sir, the judge wants to
Yes.
hear what you have to say about the last 3 months. And what you're mentioning.
Yeah, that happened in the last 3 months.
Oh, excuse me. I didn't know that. Do you recall when that happened?
It was, I don't remember the exact date, but it was about a month
Roughly.
ago.
All right. So it's in the last 30
Yeah,
days.
roughly.
All right.
Yeah.
And what did she say?
I'd say maybe a little bit over it, but yeah.
What did the caseworker say about you? That you what?
Miss Moore.
Just basically like how, well, obviously she, basically states like I am, and I don't know if she states it in her paperwork or whatever, but that's why she won't basically come to my residence and do whatever testing and the DNA and all that.
Well, what
need to
behavior
do,
did she describe?
and she won't do the home visit thing. She wouldn't come through the gate. Well, she's described it as she doesn't know what she's walking into, and basically that she feels unsafe.
I see. Do you have any opinion as to why she would think that?
Yeah, it would be the biased opinions of Christy's family, or her father mainly, and the allegations that started all of this, really.
Mm-hmm. Mm-hmm.
I've never given her a reason to feel like that towards me.
That was going to be my next question. Was there anything in your demeanor or your words that could have been interpreted as threatening?
Now probably other than nothing violent or anything like that, other than the fact of I want to see her in jail for basically taking my child from me or kidnapping her. But other than that, no, nothing out of means of the law.
Okay. So because the judge apparently is not going to give us that additional time in a week or so, is there any other point you want to bring up that has not been brought up by anyone else?
Just like the fact of basically with Kenzie being with Jason and Dawn, she's being alienated from basically my entire family because they won't let my family have anything to do with them or her at all.
Remind me whose family they're with.
They're with Christina's family.
All right, moving on. Go ahead.
So basically, like my mother, her maternal grandmother, like she would love to see her granddaughter and be part of her life, but she cannot.
She can. During his visitation schedule, she can. But he's not following his visitation schedule. That's when they do it.
Due to this, and it's because they are, they basically how they want it, and then how they want it since me and Christina got together is to write me off as dead and just to push me under the rug.
So they're not cooperating with your extended family to maintain that relationship. Is that right?
Right. And like her mother, I'm supposed to be able to see my other two children that's with her mother once a week, and I can't even make a phone call to her because if I do, she'll just hang up the phone. So, and they're through Hillsdale County, so she's not even following the court order that's in place. So, I mean, what do I do here?
Have you tried going back to court and complaining about her behavior?
I have not yet, but I mean, it's obviously she doesn't care what the law says because she's not following the judge's order now. So what really good is that going to do?
They might yank the children away from her.
But at that point, where do they go? Do they put them in with somebody they don't know?
You're adding things
That
there
just
that
makes it
we're
worse
not
on them.
talking about. You asked what the potential remedies would be. I told you, and I told you the sort of threat hanging over her head.
Yes, and this whole thing is about the well-being of our children, correct? So
I'm objecting to dialogue. This is really not an opportunity for dialogue. It's questions and answers.
Right.
This is the problem with court. You can't ever really get what you got to say out, and it's never really a thing to where anybody can understand exactly what's going on.
Mr. Wright, please stop. So the problem I think that we're having here at the moment is that these are questions that would have been appropriate for you to speak to your attorney about frankly, in an attorney-client privileged context so that you can get your questions answered before you come to court.
My attorney doesn't call me, doesn't get in touch.
Okay, Mr. Wright, no more interruptions, please. You've had your attorney's information for a significant period of time. I'm not going to entertain disparagement of Mr. Brooks on the record either. There's an order for supervised parenting time. So no, the relative would not be authorized to take any phone calls, any unauthorized phone calls. The only parenting time that your client's offered right now, Mr. Brooks, is a reintroduction parenting time program through Renee Moore because he's been absent. So I'm going to ask you to move on to something else if there's anything else, or to simply reschedule something so that you and your client can walk through where he's at in the case right now, so you can take a better look at things on a different day for a review. And I'll offer an accelerated review to everybody. How about that?
Moving on, sir. What other issues do you want to address to the court?
No,
Honestly,
Mr. Brooks, no. Ask him
I guess
a question.
none because it's not going to make a difference.
Good.
Obviously, I've seen that now. So
I don't recommend you take that tack, sir. What other issues do you want to bring up with the court?
okay, so I'm in Lenawee County now. I have been for months now. I do not have transportation. I do not have a license. I don't really have any friends. I have barely any family here. So it's hard for me to get around. What can we do other than a gas card to help that become a thing to where I can go to these appointments?
My advice on that to you, sir, is contact your caseworker and work.
I have.
Oh,
That's all in the Texas Center.
it's all in the what?
The messages I sent to Macy, caseworker. That's all in there.
Okay, messages.
All right.
I've mentioned it over and over again, multiple times throughout this whole thing. What can we do to help with transportation to get to these things?
And what was the response?
A gas card, $25 gas card.
Without a car to put it in.
Yep.
Okay. So what you're saying, if I can summarize, is you have a real and present problem of which they have offered no viable alternatives. Is that a fair statement?
Yes, sir.
What is the next issue you want to bring up?
That's it.
I get it. He doesn't have a car. He can't get there. But if you can't drive to go see your children, how in the world can you take that child? Children need to go places all of the time. And I'm not saying if you don't have a car, you can't have a child. But if you don't have a car, you have to do other things. He has to be getting around right now somehow. He's not just sitting in his house every day. Because he's alive, so that I know he's eating food. And he's going to get that food or getting the food delivered, which means he has enough money for that. He can take an Uber. He can take a bus. He has a gas card. If he can't make it to go get his children, how is he supposed to take care of his children? I know my children are adults and I still have to drive them places. My fault, I know.
Well, we might ask one more. When you were saying that your attorney never called you back, are you referring to me?
I have called the office a couple times, but I didn't receive a call back. Yes, but that was months and months and months ago. So that's irrelevant now.
I see. Do you have a case going in Hillsdale County as well?
There's a guardianship in place with Christina's mother. At the moment, yes. Other than
It has
that,
nothing to do with me, right?
no, it has nothing to do with you, and it has nothing to do with Lenawee Court.
All right. What would you like to see done that's not happening at this point in time?
I would like to revise what they want out of me, because it also states in their stuff that they want me to do in order for me to have visits with Kenzie is to obtain a car and a license, and I can't obtain a license for another year. And I mean, obtaining the car thing, I mean, I did that. That's how I got the driving unsuspended. That's with me trying to do what I had to do for the court.
Mhm.
I mean, so now I got that over my head. I don't, as you guys, I'm in a spot to where I'm damned if I do and damned if I don't, because to get to these places, I'm going to have to drive. That's the only other way other than, figuring something out. And in doing that, I'm breaking the law. So, I mean, I don't understand. Is the court telling me to go ahead and break the law to do what they want me to do, or?
No, they're not.
So then what option do I have?
Okay.
Again, this is a conversation you probably need to have with your client, not on YouTube, not in the middle of a court hearing, Mr. Brooks. So I would invite you to move on to something else or reschedule. I'm gonna offer everybody an accelerated review, if it works, on the calendars for December 1st at 1:30 p.m.
What else is on your mind, sir, that could improve the situation?
That's it. That's it.
I don't
Well, let me
understand what's going on with Mr. Brooks. This man has a plan that he has to follow. Mr. Brooks should be asking him specific questions about that plan that he's supposed to follow. On June 21st, why did you not show up to this hearing? I didn't have a car. Did you call? Yes, I called. All right. Your parents, they could have seen the child on September 16th when you had that. Why didn't they go then? But I don't, is he in the driver's seat of a car? Does that look like he's in the driver's seat of the car? To me, it looks like he is sitting in the driver's seat of a car right now, but cameras get flipped and things like that when you're doing, I don't know.
Let me suggest what I think I hear that has, you haven't said it, but I can see it's where you kind of like to go. You'd like a review of the case service plan, which you don't
Yes.
think fits your circumstances very well at all,
Correct.
which might change a whole lot of things.
Yes, sir, it would.
That I heard. With that, I'm going to move on and say I have no further questions.
Okay, cross-examination, Ms. Thomas.
No, Your Honor.
Any questions,
Josh.
Mr. McFarland?
You have a bicycle, sir? Mr. Wright, do you have a bicycle?
Look at the sun. Look at how the sun is hitting him.
Did you lose him, Your Honor?
He's logged in. Mr. Wright, are you?
He is absolutely in the driver's seat because the sun is hitting him right in the head. Right. If he was in the passenger side, unless the camera got flipped, you know how sometimes the camera mirrors.
Okay, did you hear the question? Okay, maybe the signal is, maybe he's having issues with the signal at this point, but he hasn't had any so far. Mr. Wright, can you hear us?
Yes, I can.
Okay, Mr. McFarland has a question for you.
Do you have a bicycle?
Yes.
You're sitting in the driver's seat of a car right now, aren't you?
Yep. And I did state that I obtained the car. That's how I got the driving unsuspended.
Nothing further.
Any questions, Ms. Underwood?
Are you in a vehicle with Miss Lumley right now?
No.
Okay.
But hey, nobody in the vehicle.
So you say you don't have a vehicle, but you do. Is there nobody that can transport you
No.
with the gas cards that you're provided?
I did not state that I didn't own a vehicle. I own a vehicle, but I have no license to drive the vehicle. So the vehicle sits on my property now. That's what I stated.
And you're not willing to take any accountability for your lack of participation in this case service plan over the last 3 months or even year?
Hello?
Your Honor, at this point, I just won't ask any more questions.
Okay.
Thank you.
All right, did you have any other witnesses, Mr. Brooks?
No,
Okay, Mr. McFarland, let's go ahead with the recalling or rebuttal of your client if you'd like to for now.
Thank you.
I'd like to try to finish today.
Ms. Lemley, are you still there?
Yes, sir.
Okay, Ms. Lemley, you remain under oath. Go ahead, Mr. McFarland.
Can you turn your camera on and just pan around for us?
Yes, absolutely.
Thank you. Did you wish to respond to your former counselors? Take your sunglasses off first because we're in
Okay,
court.
She's driving. Ms. Lemley, we're gonna need you to pull over. If
Okay.
you wanna continue participating, I am not gonna allow you to do that while you're actively driving the car.
Okay, I said I'm about to pull into my work parking lot right now.
Sorry, Your Honor, I did not notice that.
Oh, well, I don't even think we would have known unless you asked her to pan around.
I said I'm sitting at the red light that's on the corner at my work. So as soon as I can get through this red light, I can turn into work.
Okay, Mr. McFarland, are you gonna have any other witnesses?
No.
Ms. Underwood? No, Your Honor. Ms. Thomas?
No, Your Honor, thank you.
All right, so after Ms. Lemley is finished, assuming there's nothing else that's triggered by her testimony, we'll go ahead and conclude today's review. Is everyone available on that December 1st date at 1:30?
I'll be there.
Sorry.
That's okay. That's why I asked. While we're waiting for Ms. Lemley, let's look at calendaring.
I'm available on the 2nd for that month, but the 3rd to the 5th I'll be gone as well, if you're looking at any of those dates.
Tuesday, December 9th at 10 o'clock for 2 hours.
I'm available.
At what time, Your Honor?
10 o'clock from
Thank
10 to 12. I'd like to budget 2 hours to make sure that we get everybody's testimony.
What was that date and time?
12/9 at 10
For what?
for our next review.
Okay.
That'll be our 6th review in permanency planning hearing. Ms. Lemley, we're waiting for you to let us know that you're in a spot where you can safely testify.
Yep, as soon as these cars right here pass, I'm turning in.
Your Honor, this is one of the reasons I don't like Zoom. It trivializes what we're doing here.
I mean,
And I apologize. I could not afford to miss another day of work.
Your Honor, I am taking a look at my calendar as I occasionally have cases with Judge Angelo. That was December, what date?
9th at 10 o'clock.
So first is not good.
Correct.
That's fine, Your Honor.
Good.
Okay, I am parked.
Thank you.
Okay.
Christina, it sounds as though you wish to respond to what your counselor said, correct?
Yes.
This is your opportunity. What's the first issue you disagree with her testimony?
It actually was not my first biggest thing was not what she said. Miss Underwood had confused or misunderstood something I had said. I did not tell the court that the June or July dirty drug test that they are submitting. I did not tell the court that was from cleaning another resident's room. I was not even in housing at that point, so I would not have been in a resident's room. That situation in which I was referring to in my previous testimony happened back in December.
So are
I
you
got there
agreeing that,
following-
so are you agreeing that what the witness said is true, that you said that you did relapse and took meth? Is that what you're saying?
The one. But
Okay,
Miss Underwood's situation, she put two separate situations into the same situation.
So there's only one time that you actively took, and that was in July. Is that what I'm hearing?
Yes.
Thank you. Did you wish to clarify anything else your counselor testified about?
When she stated the fact that I personally missed all of the appointments, I did go back through my text messages. There were 3 separate appointments that she had contacted me to reschedule that never did or canceled last minute. And then she was the one that also said that I didn't have to come to the office. We could do our sessions over the phone. And so I assumed that when we were doing over the phone sessions, that those counted as sessions. She was also aware that the nights that groups were, I had to work. We discussed that right at the beginning of me being in outpatient. And then there were, when she said, I wasn't real, that we had a little very brief conversation about me moving back to Jackson. She never mentioned anything about me not being ready. She was actually helping me look places up to move to in Jackson. And yes, that was a plan I was working on, being in contact with the Jackson store, transferring my job and everything. And so I guess there's a lot of things that she said here that, she acted or said things totally differently face to face with me than the way that she just described and answered questions here.
Do you have any response to her saying you left the inpatient prematurely?
No, because her and I had quite a few conversations about the fact that, and even you and I had conversation about the fact that the distance between my daughter and me is a problem, clearly. With the transportation with her, it is a problem. So everyone's recommendation and what CPS wanted is me to move back closer to her. I had multiple conversations with her about, you know, it makes me very nervous to move back to that hometown to be right back on my hamster wheel. You know, multiple times did we talk about these things. And so I
Okay.
told her, you know, I'm not really ready to just up and disappear out of all of this. And she said that, you know, everything would be okay, just reestablish myself with, you know, she encouraged me the best that, you know, I thought she could. Never one time did she tell me, I think you're making a big mistake.
Thank you. Okay. Would that be the totality of what you want the court to hear? Would you agree?
Yes, and then just to clarify that Miss Underwood was taking like 3 separate occasions and mixing them into one.
Thank you for that clarification. I have no further questions. We'll see if any other attorneys have questions for you.
Cross-examination, Ms. Devis.
So I don't
None, Your
know.
Honor.
Mr. Brooks.
I know there's a small child, a baby. And that's what this hearing is about. It sounds like her parents have 2 of his other children, a little older, but they didn't really expound on that. Are those 2 children hers? I don't know. Why would they be with her parents if they're not hers? I don't know. I don't know. You know, maybe she met him, they started dating, and, you know, they had all 3 of these children in the same house, and when CPS came, they took all of them, and her parents said, it's fine, I'll just take them all. And that's possible. But I know this is about one hearing, and that's for one child, a very, very young child.
No, Your Honor.
Ms. Underwood.
Okay, so let's get this straight then, Ms. Lumley. You indicated then that you tested positive in December 2024 for meth?
No, I did not say that. I did not say I tested positive for meth at all.
Okay, but you indicated that I was misstating what you said. So when we asked about 2 positive drug screens that were in May and July of 2025, you testified that you got those retested and that they were exposure levels, and that was likely due to you cleaning another person's room. Is that inaccurate?
Yes, that is inaccurate. What I said was that those 2 that came back of this year were sent back to the lab. They came back as an exposure level positive. It doesn't matter if it's an exposure level or a use level, it's still a positive drop. However, in the recovery world, there is a difference between a use level positive and an exposure level positive.
Okay, so then did you use? Did you use then, I'm asking you, did you use on May 5th, did you use in May of 2025, methamphetamine?
No, I did not use them then.
Okay, then how did you test positive?
That came back as an exposure level positive.
Okay, so how would you have been exposed to methamphetamine when you were in rehab?
Being anywhere, being on the bus systems, being at the shelters where I do community service, there's all kinds of places that you can be exposed to it.
Okay, and then the same would be on July 15th of 2025 when you tested positive. Was that also exposure level?
I'm
Here,
sorry?
she already testified, she tested that there was a consumption. I asked.
I just want to look really quick in here.
Well, Mr.
Asked and answered.
They
if
have-
you might.
Do I have a
Wait, does that mean all of us would have exposure levels if we dropped right now? If we all went and dropped right now, some of us would fail. Some of us would flat out fail. But the rest of us, would we all test dirty for meth because of exposure level? Because we're everywhere. Although some of us, actually, we would all fail because some of us would fail so hard on our tests that they would make all the other ones, all the rest of us fail too. That's how hard some of us would fail.
Oh, yes, we have 2.
Okay, Ms.
The-
Bresnahan, you accidentally, I'm sure accidentally came unmuted, and we've got enough to try to get through here this afternoon, so please be careful of that.
My objection is asked and answered, Your Honor. I asked her that very same question.
Well, I'd like to give her the opportunity to clarify with Ms. Underwood since she is,
I'll withdraw that.
Thank you.
Okay.
I'm gonna have to overrule it if you did. Go ahead.
So did you use in July of 2025 then?
No,
You just admitted to, when
It's not
being
a
questioned by
thing,
Mr.
Phyllis. She's a
McFarland,
liar.
that you relapsed in July. So is that an
In the
inaccurate
recovery-
statement?
in the recovery world, any positive test is a relapse.
Okay, so then Ms. Reyes is lying when she indicated that you admitted to use for the July 15th of 2025 test?
I'm not saying that she's necessarily lying, maybe misinterpreting or misunderstanding something that I had said.
Okay, now you indicated in the last hearing that you did not have a vehicle to get to your colors screenings, however, you're driving now. So are you able to make it to your colors when you're called?
This I borrowed. My vehicle is not legal yet.
But you can borrow cars to get to work, but you can't borrow cars to do your drug tests?
Very, very, very rarely can I borrow a car to get back and forth to work. And that's not a scheduling thing. That's not a call up randomly in the morning and say, oh, hey, I got to do this.
Liar.
This I had made arrangements for a special occasion because I was attempting to come down there to be there for court. But after talking to my boss, I could not miss any more work. So I had to come to work.
No further questions.
Okay. Let's head to comments and closing, beginning with Ms. Thomas.
Thank you, Your Honor. At this time, I believe that it's appropriate to ask for a goal change to adoption. I do not believe that guardianship is appropriate given the age of the child and given the lack of either engagement from the parents and or benefit from services from the parents. I think that this child deserves permanency and stability and finality.
I'll be right
We
back.
do not have two parents who seem to be committed to addressing the issues that cause a child to come into care. It does not seem that there's even a baseline understanding of what's happening as really into their worlds. And I think that their credibility is very questionable at this point in time. Your Honor, Ms. Moore has definitely made reasonable efforts to assist this family in reunification. We've seen, based on their conduct and capacity, the lack of ability to work truthfully and or honestly or safely within this system. There's a lot of lack of accountability and deflecting and blaming others for the current situation in which these parents find themselves. However, that's not the child's fault. And I think that at this point in time, Your Honor, I know that we've already scheduled or have on penciled in an accelerated review. At which juncture I don't know that we would have time to, if the court does order us to file a petition at this point in time, don't know that that would be the date and time we could hear a termination hearing, or have a hearing on a termination petition. However, I think that's forthcoming. The current family placement is providing the child with everything that she needs, and that this child's also getting exposure to half siblings. And so I just think that what's happening apart from the parents is beneficial for the child at this time. And I look forward to any updates and hopefully maybe a turnaround for these parents. But I just, based on the report that we have from the Odyssey House, Ms. Reyes' testimony, Ms. Lemley today has impeached herself based on testimony from the last hearing, which is, easily on YouTube. And then she also impeached herself again in this hearing. I think Ms. Reyes really was correct when she said, maybe mom is still in the contemplative stage of recovery rather than an active recovery. So with that, Your Honor, I just ask for the continuation of placement, continue ordering the parents into the case service plan. I know that there's a lot of complaints from the parents about transportation. However, that is just one element of it. And there are several ways in which our parents who struggle with transportation do engage in services. I believe that we have a very competent team from the private agency that can assist with referrals. I think it's just a matter of communication. And while the department, the agencies have a duty to provide those reasonable efforts, the parents have an equal responsibility to comply with and engage in those services as well. And as I always say, our county and this court particularly demands active efforts from our caseworkers. And I believe that's what we always get. And this is more than just a monthly check-in and sending a name and number of a place where parents can call to engage in services, which is technically all that the law requires from us. So I think that at this point in time, we've done what we can from the agency's perspective. And there's just failure to benefit. And there's, I think it's time to shift completely towards a goal of adoption. Thank you.
Comments, Mr. Brooks?
Well, based on what I'm hearing from my client, I wish he and I had communicated more closely quite some time ago, and I would have attacked this case service plan back when it was really and truly more appropriate. And I guess that's what I intend to do now, is file a motion to review that case service plan, which, based on what he's telling me, doesn't really fit his circumstances at all. I also would have corrected his misapprehension that the fact that he doesn't agree with some of this stuff is irrelevant once it's an order of the court. If he and I were talking, he would have known that. But I will be filing a motion to review the case service plan before the next hearing.
Mr. McFarland?
Well, Your Honor, I asked Ms. Moore, until the incident with the dog, if the agency was on track with my client's desire for guardianship. The answer was yes. It was the issue of my client being there, having your child introduced to the dog at the residence of Mr. Wright was the turning point. It wasn't the testimony, the discharge summary of the counselor. All this is obtainable. It was probably knowledgeable by the agency. It was past history. Despite that, my client was having unsupervised visits, Your Honor. I think her testimony is credible when she says that she's not at a point right now where it'd be fair to the child to have the child back, but she is on board with a guardianship. So why would she lie about that and then lie about what's happened with the dog? That doesn't make sense. Mr. Wright's in Adrian, in Lenawee County with the dog. She wanted to make sure the child is going to be, the dog is going to be appropriate with the child. She made a serious lapse in judgment. We agree on that, Your Honor. She agrees on that, Your Honor, in retrospect. But it was not her intention to violate the court order. If it weren't for that, this hearing would not be a question, it doesn't sound, of termination or not putting that on. We are asking that the goal remains guardianship. We're not asking for reunification because she's acknowledging that guardianship is in the best interest of the child, that goal continue as the agency had desired it to continue prior to that incident, that my client's unsupervised parenting time resume, but with her giving an exact itinerary. This is what she's going to be doing each and every hour of the day. So we know exactly where she is, what the expectations are. If there's a telephone call or they call her, she's going to pick up and pan around. I think there may have been perhaps some questions in everybody's mind. Is she with Mr. Wright right now? That's why I asked her to specifically pan around to prove that she is separate from him. She's not with him, that she's learned her lesson. I think her testimony is very credible that she would have exploded, that she didn't explode, because that was not appropriate for the child when this happened, but she was, and I think that's inappropriate. So we are asking that if the court does reject the guardianship, that'd be a dual goal of termination and or guardianship if the court goes that route. But obviously our request today is for guardianship to remain on schedule, at least until we come to our next hearing. Thank you.
Ms. Underwood?
Your Honor, it's unfortunate that we're in the circumstance that we are right now. However, it is my job to advocate for the best interest of this child and for permanency for her. She has been in care with relatives for over a year now, since she was a baby. And with respect to Mr. Wright, he has done absolutely nothing to provide for her or to work his key service plan, despite several attempts from the department and attempts to engage in the services. It's easy to play the blame game, but again, whether he was convicted of issues or not, of crimes or not, the issues are still relevant to this case. As far as Ms. Lumley goes, I would say that we were all very hopeful that there was positive progress being made in her case. However, it is clear that there has been a backslide in the last review period. Unfortunately, Ms. Lumley got caught having the child around Mr. Wright. She purposely went there. She took the child there, didn't let Ms. Moore know, even though she's supposed to provide an itinerary of what she's doing for each parenting time. And again, we can call it a lapse in judgment, but again, there is no way a parent would believe that that's acceptable. And the excuse about a dog and making sure that they got along, why would that be a thought in anybody's mind? When
No more interruptions, Mr. Wright. You've had your opportunity to
Well,
participate.
everybody's making.
I would recommend you reach out to your attorney before the next review. Go ahead.
when that was even a thought in her mind when a
No,
guardianship
hold on,
was-
hold on.
Mr. Wright, if you can't stop interrupting, I'm going to have to excuse you from the meeting and you can just watch the remainder of it on YouTube. Please don't unmute again.
Your Honor, the fact that the dog was even a priority at that point just shows where Ms. Lumley's priorities lie. And again, I just think it's an excuse to get out of what happened. But again, Ms. Lumley was impeaching herself and being dishonest on the stand, talking about exposure levels. She's continued to miss drug screens since she's been put on colors. However, she's able to have a vehicle when she needs to get places that she wants to go. But her e-bike can't get her to do her drug screens. Since her unsupervised visits were taken, the department has offered her supervised visitations, which she has chosen to not participate in, as well as she's had the ability to FaceTime the child with placement and has not attempted to do so once since she was caught at Mr. Wright's home. Again, I think the priorities are misconstrued here, and I would encourage Ms. Lumley to take a good look in the mirror to determine, really what's going on here. And if she does need help, then she needs to admit that and get back into treatment so that maybe it's not too late for her to get her life together and get her kids back. Placement does allow this child to have regular visitation with her two full siblings who are in guardianship with another relative. I believe that permanency should be the goal here and that should be adoption at this point. There's just a lot that's been going on that is contrary to this child's best interest, especially with respect to dad. Again, we're no further than we were a year and a half ago, approximately. And again, Ms. Lumley's priorities seem to be in the wrong place right now. And again, it's in this child's best interest to pursue permanency, which I believe would be adoption in this case, Your Honor. She is currently in the least restrictive and best environment for her, and she is too young to express a preference as to where she would like to be at this time. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review and permanency planning hearing. The child in this case was born in January of 2024. And she's very young. She was removed from the care of her parents June 21st, 2024. That means she's been in an out-of-home placement for over 15 months. And at this point, the court has to look at what it means for this child moving forward and what's in her best interest, and whether or not it would appear that either parent would be able to continue successfully towards reunification in order to provide a safe and secure home for her, drug-free, criminality-free, and that would meet her needs. Mr. Wright has not been engaged in his case services plan for some time, including the last 3 months. I carefully reviewed the text messages that were provided today by Ms. Moore because of her concerns on how Mr. Wright was addressing her, and she felt threatened by those. His request to have the case services plan revisited, I think, will have to be handled very carefully by Catholic Charities, considering the content of these text messages, which, by the way, do not ask for assistance with transportation, but do certainly seem to contain several different ways of letting Ms. Moore know what he thinks of her, to be polite about it, as well as what he'd like to see happen to her, different ways she could meet her demise in different paragraphs. So if Mr. Wright reaches out to you to do that, Ms. Moore, I would ask you to actively engage Mr. Brooks in that process. And Mr. Brooks, I would ask you to be present during any family team meeting or team decision making, whatever you're calling it, sorry. So that you can try to help Mr. Wright navigate that space safely, both for himself and for Ms. Moore, if he does want to revisit that case services plan. But I would note that at this point, we're 15 months in. There was an adjudication held. He did admit to substance use at that point and to criminality. He was incarcerated at the time the petition was filed. There's an active warrant out for his arrest at this point. There's no information on housing, employment, or progress in any other areas of his case services plan. And there does not appear to be any effort to reconnect with his daughter through the reunification opportunity given to him that's been outstanding for, I think, at least 2 review periods. So there's certainly a significant risk of harm associated with returning his child to his care right now. There has been, and there does not appear to be any movement whatsoever on those case services plans that would allow us to return the child to his care. As it relates to Ms. Lemley, there was a lot of very concerning testimony across the 2 days of this review and permanency planning hearing that was inconsistent. I sincerely hope that she is still in her recovery and that she can show that through some drug screening. The testimony by Ms. Reyes today was very concerning also, that she had abandoned her rehabilitation efforts early, both through inpatient as well as outpatient. That was actually new information that came to the court's attention today. The excuses about testing positive for exposure levels that could be contaminated from anywhere is simply incredible. And I do agree with Ms. Underwood that there are significant concerns at this point about what's actually happening with Ms. Lemley in her recovery. But nevertheless, at this point, she has appeared to make some progress in some areas, but again, we don't have anything from a current counselor. We heard that she didn't complete counseling services with Ms. Reyes. So there's a lot of outstanding areas of concern still with Ms. Lemley. She herself today has shared with us that she supports a goal of guardianship. The child is very young. She's very comfortable where she is. She's doing well there. And the fact that Ms. Lemley cannot provide for Ms. Wright, admittedly at this point, simply leaves it to the court and the professionals to determine what is the best course of action for her daughter moving forward. And that is adoption. She's very close with her relative caregivers. Neither parent is proving to be a resource to this child at this point. If I were to consider guardianship, I would look at whether or not these parents have an investment or a bond with their child in a positive way that would help her to grow. At the last visit, Ms. Lemley's decision to take the child to Mr. Wright ended up with, and to lie about it directly before she went there to Ms. Moore, and then to try to blame it on the dog is remarkable. The child came back very unclean, and we have evidence of that as well. We know Mr. Wright is not in active recovery. We know Ms. Lemley's at significant risk of relapse. There's just so many concerns here in allowing these parents to even continue to have contact with this child because of the liberties that they're taking with her. She needs to be in a safe, stable home, free of domestic violence, free of substance use, and free of things that will compromise her ability to grow into a responsible adult, as Ms. Underwood put it. So there's a lot of reasons, but those are the main ones that the court is considering in changing the goal to adoption moving forward. I am going to leave the December 9th date on the books. If the termination petition is timely filed and served by the department, we'll conduct the trial as part of that next review and permanency planning hearing. In the meantime, the child will remain in her relative placement. That is certainly the safest and least restrictive under the circumstances. We'll have plenty of time for the review, even if it doesn't also encompass a hearing on a petition for termination of parental rights, but the order will reflect that that has been directed by the court today. I'm certainly fine Ms. Moore in satisfaction for applications, Ms. Underwood and our advocates. Thank you everyone for your time, efforts, and testimony today. Good luck to everyone between now and when we come back in December. And unless there's any questions, that's all for today.
One question. For termination, the petition had to be filed in the statutory time frame, correct? Right?
Timely filed and served is how I like to phrase it.
Thank you. Thank you.
We saw them before, if I remember correctly. We saw them both before, and Mom was doing really well last time. Song written, next music, here now. Thank you, Jude. Thank you so much. I appreciate it. Oh, Kelly, you came right at the end. It's over. And we got Bill here. Hey, Bill. Wait, Raven is here? Oh my gosh. Everybody, Raven is here. Hi, Raven. Y'all just walked in, strolled right in at the very end. It's over, but I'm going to start OJ now. So back to these guys. We saw them before. Mom was doing really well. Mom must have not done well this last one. But we'll see what happens in December. December's a long... Every time Raven walks in, Raven tells me about my microphone. Is that better, Raven? I know, this headset sucks. My mic is right here. But I need to do stuff. I'm a mess. Yes, hi love. Yes, Josh, you too. Are you still in Florida? You're still in Florida. We would know if you left. Alright, I'm gonna start OJ. Thanks for coming out, guys. I appreciate it. I hope you guys have a great day. I hope you don't do anything. You know, last week sucked. I hope this week is better for every single person involved in this week, and that's all of you. And I hope you don't drop any dirties. Bye, guys. Here comes my song. Hi, Lozzie Love. Crystal.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me